We have received some written materials with respect to this application, and Mary Fitzgerald, who has done a superb job in keeping us organized with respect to this hearing and application, has given me a list of those materials that we've received since November 6th. Three materials received in that interim period. A letter or information dated November 12, 2014 that addressed issues of prior site contamination and subsequent remediation. A letter dated November 24, 2014 from Peter Freeman concerning the local wetlands bylaws and comparing it to the state provisions to see if they were more stringent. And then finally we received a second letter dated November 24, 2014 from the Milton Fire Chief regarding comparisons between 131 Elliott Street and 88 Wharf, which was a subject that came up during the last session of the public hearing. I understand there's additional materials that have been presented tonight. Peter, is that right?
Yes.
That I haven't listed. Could you just list them for us, if you would, as to what's been submitted on behalf of the applicant?
What I just handed to your secretary, Mary, so that I wouldn't have to give out this. We have a memorandum, and we also have with Kevin S. Hastings, a memorandum related to the fire code safety issues from Sullivan Code Group, R.W. Sullivan Engineering. And as I had mentioned in email, I understand that because it's just being submitted tonight, that certainly we understand that the fire chief and or building inspector and anybody else wouldn't have had a chance to look at it and to respond. I had initially thought that we would defer even presenting on it until the next hearing. Mr. Connolly wanted to have Kevin here, and the pleasure of the board, naturally, we understand fully that neither the board nor, as I said, anybody else, town departments, would have had a chance to see it. So if you want us to present either now or after we go through a few housekeeping things, or just defer, that's certainly up to you. The other thing that we have, which I don't think is submitted, is a large-scale plan showing the grading and the heights. That was a question that came up last time. We didn't have a chance to submit it before tonight. That's relatively brief, so again, whenever you want us to, our architect, Kurt Raber, can hand it in and just briefly explain that to you. I think those are the only...
The existing conditions, the new existing conditions.
I'm sorry?
I see that there's a...
Oh, okay, did you just submit that tonight?
I brought it.
Oh, okay. I didn't-
There's a
okay.
plan that apparently been submitted to us that shows existing conditions, and it's revised through November 24, 2014? Okay, that's fine. Well, Peter, I'll leave it to you as to what you want to present. We're here tonight, happy to hear whatever information you want to present to us. Before we get underway, just to sort of summarize, and I'm speaking only for myself and not for the other members of the board, but in thinking about this today, preparing for the hearing, it just strikes me that although there may be other issues that I've missed or failed to list this evening, but it seems to me the four principal issues that have sort of emerged through this process so far have been traffic, parking, Concom issues, and most recently the fire safety issues that were identified at the last hearing. And we can, at the appropriate point, we can talk about each of those issues. Peter, I know that as it relates to the Concom issues, you have submitted a fairly detailed letter that I referenced in my beginning remarks of what we received since the last public hearing. And in reviewing that letter, it strikes me that the essence of it is that you're saying that the local bylaw provisions are not more stringent, and that therefore we should feel comfortable in waiving them. Of course, I can think of a counter approach to that, which would say, well, if they're not more stringent, then why do we need to waive them? But we can leave that for another day. That was just something that struck me this afternoon. Because the fewer waivers we have to grant, it seems to me, the better off we are. But in any event, the traffic issue is sort of distilled to its essence from the way I understand it from both the police chief and the DPW people, is that they think that the traffic intersection requires a signal. And it seems to me to be the essence of what people are suggesting as it relates to traffic. So those are the issues that I think are the principal issues that have been identified and are on the plate before us. I don't know whether you would plan to address all or some of those tonight, but that's sort of where I see us heading in terms of the things we have to wrestle with in terms of this application.
Sure, and I can respond briefly. and then suggest an order of presentation. On the traffic and parking, certainly at the next hearing, which I hope will be nearing the end, we can go over that, although we have had both our own consultants, experts on those issues, as well as the peer review consultant for the town. And, you know, I don't know that either of those consultants need to come back. We know that there's I think, a consensus that, you know, the police chief himself, I think in the course of the discussion itself, a little bit different than the seeming inference in his written letter, was he realizes that it may or may not be called for or appropriate for a number of reasons to have a traffic light, but he thought that it bears further study. And that seems to be what the consultants were saying, and as you pointed out, it does appear that everybody agrees that it's an existing condition, and it would be, and I believe I'm more or less paraphrasing you, it would be not within what the 40B case law typically says is done when dealing with an existing condition, to throw it all on, you know, on the applicant. So I don't mean to get into that in great detail tonight, but certainly we can address that again. I guess at the end of the hearing, maybe I would ask you if you think we should bring Jack Gillen again, which if you felt we should, we could do that. So that's parking and traffic. On the Conservation Commission issue, I think I'll save till a little later just a brief commentary of my memo, which you did accurately summarize. What I would want to do is just very briefly, it's probably 30 seconds or a minute, just bring you up to date on where we're at since the last hearing with the Conservation Commission, because we did meet. We had a hearing last week on both the demolition application and the redevelopment for the site application. And in essence, some progress was made, but not to the point of having any conclusion. In essence, we agreed that certain additional information would be provided to the Conservation Commission. And most importantly, which also ties into what I said at the end of my memo, we agreed both with the Conservation Commission and the DPW that we would apply for and do what's required under the DPW stormwater management permit. So again, in trying to help you to a comfort level dealing with Conservation Commission / stormwater management issues, we believe that that will help legitimately, because you don't have to worry that you're waiving that particular stormwater management permit for that process. So although we don't have details to report, but that's progress, I believe, in the right direction. So we'll have to see what happens with the Conservation Commission. Our next hearing, I believe, is December 9th. It may well be that, you know, we would be comfortable and would believe that it's appropriate to say we may not be done with them by the time we would be ready to finish up with you folks, and we would probably still want to finish up with you folks. And so, not to discuss now, but to the extent that you have any questions about the Conservation Commission bylaw, again, I can give you an answer which I'll defer as to why I still think it makes sense to waive it, even though we're saying it's not more stringent. So that's the Conservation Commission issues. What I think I would like to do before having Kevin Hastings just report on his memo related to the fire safety is have Kurt hand in the plans and just briefly explain. I think you may have questions, so I shouldn't presume that you don't have questions, but it's pretty simple in terms of the grading plan showing the calculation of height. And then have Kevin give his presentation.
That's fine.
Thanks.
Sorry.
Thank you.
It's next one. So there's one for each of you.
Great, thank you.
Yes.
Do you have one?
You don't have one?
Because you're the official record keeper, so.
Mary wants it officially.
I believe it was is this one? Is this working? Chris. Is that working? All right, thanks. What we've passed out this evening is a copy of the building elevations that are unaltered from their last submission. However, we have overlaid on top of it in red a description which hopefully will answer a question that came up last time. And that was a question about the height and where our building is in reference to the existing mean grade. And as you can see on the bottom of the drawing, there's a dark horizontal red line. And approximately 80% of the site is in the business district. And the lower red line is it defines the grade at 31.43 feet. That's the mean grade in the district. The small piece on the left end of the drawing is the residential C district, and the grade there is at 37.05 feet. The thinner red line nearing the top of the drawing shows the allowed height in each of those districts. And of course, you can see there that only a minor part of the proposed development extends above those lines. In the clouds with the arrows, we've defined the allowable height for each of those districts. So this is just presented to you tonight to help answer that question that came up, to illustrate where the building is reference to the allowed height of a building in each zone. We can come back to this in questions later if you like.
Okay, so I don't know if you have a microphone. If that flat thing is a microphone, I guess they said. So Kevin Hastings from the Sullivan Code Group, or RSW Sullivan Engineering.
Okay, thank you. Yeah, so I was asked to look at the building with respect to fire department access. I made a visit to the site to look at the existing conditions, looked at the proposed architectural plans, and as well as the proposed site plans to see what was being called for as far as fire department access. And then we took a look at that and the Mass fire prevention regulations with respect to the requirements for fire department access, and that's what's summarized in my memo. The two, I guess, primary criteria in the fire code are that each building has to have a minimum of one fire lane within 50 feet of at least one entrance of the building. In our case, clearly you have, Elliott Street, providing that access in addition to Central Ave. And the second criteria, too, that from the fire lane, you're required to be able to get to all sides of the building within 450 feet of travel, foot travel. And so based on the current plan, if you were to either leave from Elliott Street or Central Ave, you can get to that kind of back far corner within 260 feet maximum to the absolute remote corner. So it's well under the 450-foot limit that's in the fire prevention code. So based on that, as far as what the Mass Fire Prevention Code requires for fire department access, the access provided by Elliott Street across the main front of the building and on the side piece off Central Ave, complied with the state fire prevention code in terms of minimum access. It wouldn't necessarily have to have access on the MBTA tracks in order to meet the code. Obviously, that's subject to the discretion of the fire chief whether or not they choose to use that in any manner during a particular event. But as far as meeting the minimum code requirements, again, that the two public roads that are on each side of the building would provide that required access.
Right, is there any questions?
I have a couple of questions. 520, you reference a building fire prevention regulations, 527 CMR. So 527 CMR what? What part of 527 CMR deals with access?
Yeah, so if you look at that, I guess on the first page, we based our analysis on the new fire prevention code, which takes effect in January, and would apply to this building. So in the previous codes, it was a state-written code.
Okay, that's not what I asked. What I asked was, I do a lot of state regulatory work, and in my regulatory work, which is usually within the Division of Insurance, the first number of the code is the code chapter, 527. I'm looking, maybe I should have been clear, I'm looking for a specific citation
Sure.
to that portion of 527 that deals with access by the fire department.
Sure, okay, so I was just trying to explain, so the code basically adopts a NFPA standard, so the actual sections are from NFPA, when that's attached on the last page, but it's basically NFPA section 18.2 is the
Oh, okay,
is the
thank you.
section.
I'm sorry. So it's 527.18.2?
That's how you'd reference it, right, so the state adopts that, and then there are amendments to that particular chapter of NFPA.
Okay.
I can tell you while you're reading if you'd like to. I did forget to mention just the last part, last bit of the memo just had to do with, building code requirements in terms of the proximity of the new building to the lot line and any potential future construction that could potentially happen on the adjacent parcel. And the primary point there is just to say that the building code is concerned with the location of the lot line. That sets the required fire ratings and limits on openings for the building we're proposing. It's essentially blind to what happens on the other side, and that obviously any construction on that lot would have to follow the building code, depending on how close they were to the lot line. But all of the applicable code requirements are strictly based on how close our proposed building is to the existing lot lines.
Yeah, obviously, we're just reading this for the first time, or at least I am. It came to us this afternoon, so I haven't really had a chance to read it, much less to digest it. But let me just ask you a practical question. So the fire chief comes and says to us, this is an unsafe condition from our standpoint. We're the guys that fight the fires, and we think it's unsafe that we can't get to the MBTA side of the building with our apparatus. And we think it's unsafe that we can't properly use ladders on that side of the building. And I went with my 7-year-old grandson on Saturday morning and took a look at the building, and I can see his point. I mean, I think it would be very difficult to put a ladder up there with the existing lines that are there. How do we deal with that as a board? So you give us regulations, and I can read them probably as well as most, and I understand what you're saying, but how do you resolve that tension? How does a board in our position say to the fire chief, you know what, you're wrong, or the three of us, 3 lawyers, we think you're wrong about fire safety. How do we do that? That's the tension that we have, and that's what we have to address. Right?
I'll wholeheartedly agree with that was why I was being the way. The fire chief's comments really, really trouble me. And so what my chairman's comments here are kind of where I'm at.
Yeah, I think for me, sorry, should brought some water. Really need some water.
Do you want to take a break and get a drink? There's a bubbler outside.
Here, bubbler. Real quick.
Take your time.
So yeah, I was going to say that when I confronted with that scenario, we do a lot of consulting on construction projects and have requests from officials, and that's why I guess I always fall back on whether it's the building code or the fire code. I mean, that lays out through committee processes, through a lot of deliberation, but we have to set rules, set standards, so that it's fair to every project, that there's the same set of rules. And that's, I guess, what I lean on is the building code or the fire code to not necessarily define what's safe or what's not, but to define what's a reasonable level of safety or access to provide.
You said that 527 here is a new edition of the code. Did this particular provision stay the same, or is it changed from previous versions of the code?
It did change a little bit. Like I said, the previous edition was state written, so it's where this is adopting a model nationwide standard. I didn't get into the existing one, but I did bring it along with me. It's somewhat similar. The language is different, but the current version that, again, expires in January talks about having a minimum access on at least one side of the structure for a residential building. And it's not as, doesn't have dimensions and distances. So in some respects, the newer code's a little more specific as far as where the roads have to be and how close they have to be to the building. But basically, it didn't require more access than what we're proposing to provide, is the bottom line, I guess.
Okay.
In section 18.2.3.3, which is multiple access roads, it contemplated a circumstance where maybe more than one access road could be required. And I couldn't quite figure out what AHJ is. Who's the AHJ?
It's just an acronym, I guess, for the authority having jurisdiction, so it would be
So the
fire chief.
fire chief.
Fire chief.
Right.
So if the fire chief said, and they didn't say this, so maybe they'll come and talk a little bit more at the next hearing, but at least I
Well,
don't.
the fire chief hasn't seen this report, obviously.
Well, sure, but that's neither here nor there for the purposes of this comment. I mean, he didn't say that any single road that was presently available was insufficient. He suggested that you needed to have access on all sides, basically, as opposed to just one access road on one side that you then can reach by foot or whatever around the other sides of the building. But they do have, the local authority does have some discretion under this code to require more than perhaps the code would otherwise suggest.
Yeah, for that particular section, our comment was that as far as the minimum requirement is, either road, either Central Ave or Elliott Street, could meet the minimum requirement. So in the section you're referring to is saying that in some situations, the fire official may require multiple, and so they basically act as multiple ways of approaching the building, multiple ways to access the building. So even if the fire official felt that this was necessary to have a second way there, that we had felt that, or I had felt that the two roads actually provide that.
So from your perspective, do you see any safety issue associated with the inability to get to that other side of the building from a fire safety standpoint?
Well, me personally, I put a lot of stock in sprinklers, and this building will have a full commercial sprinkler system. The historical record of sprinklers and fully sprinkled buildings and fires is pretty impressive. So at least from a personal standpoint, I'm not concerned with that. I'm also not tasked with running the fire department. So, but personally, I didn't look at this as a dangerous condition or unsafe condition.
Ted, did you have any questions?
I don't have it in front of me, but can you remind me, is on the riverside, is there any distance between the building and where the terrain drops off to where the MBTA track is?
Yeah, I believe on the current plan it's around approximately 5 feet. I believe
10 feet.
From the lot line, which is in the top of that wall, and it's 10 feet to the lot line. It might be 5, hold on.
I thought it was
Yeah,
5,
it's 5, sorry.
not 10.
Yeah, it's 5, I'm sorry. It's taken on the side.
And you're saying there are no regulations in the code that deal with the distance or how much free space you need on any side of a building?
there are some related ones. Like I said, the building code governs it based on, so depending on how close you are, you have limits on windows and having to have fire-rated walls. So the fact that we are 5 feet does put some requirements on the building as far as, again, the windows. But there's not a minimum that says you can't build to the lot line, say, for example, if you had, other than zoning regulations, but if you had building code and fire code, you're not prevented from building right up to the property line.
Out of curiosity, I mean, are any of the units planned to have, I mean, are there fire escapes planned on that side or anything of the building?
Kevin Hastings, no, right, no, I mean, the building basically has a corridor that leads to interior stairways at both ends. I think one of them discharges out the front, another one discharges towards the, I think that's Central Ave, right, Central Ave side of the building. So yeah, there's no egress heading straight to the back of the building and someone having to walk, 200 feet around the back of the building to reach the public road.
Okay, thank you.
All right, anything else?
Additional.
Okay, I don't have anything else at the moment.
Just one other thing, and I say this with some hesitation, except we're all lawyers, and it is a law case that's relevant. It happened to be my case, and Kevin Hastings happened to be the fire safety code expert. The fire safety issue wasn't exactly the same, but it was somewhat similar, related to a town that didn't have a fire truck with a ladder high enough to go to the top of the building. And more similar to this discussion is the discretion that a fire chief is allowed under the code and how that fits in with 40B. And it's a Supreme Judicial Court case, so, again, I'm not suggesting in any way that you have nervousness about the fire safety issue, and we believe that we have and will continue to satisfy you. We'll bring Mr. Hastings again when the next hearing, if the fire chief is going to be here, or we'll just bring him anyway. But on the other hand, given the question by three astute lawyers, there is relevance to this particular case. So, I'd rather have you read it, and if it leads to questions, that's fine. I'm not trying to win the battle based on law cases, but it is relevant and it's instructive. So it's the Zoning Board of Appeals of Sunderland versus Sugarbush Meadow LLC. My client is 464 Mass 166, decided in 2013, and the fire safety concerns start on page 178.
Respectfully, Mr. Freeman, that was not a building next to an MBTA rail line.
I didn't say that all of the facts were identical, it's a different building, but in terms of fire safety code issues and the discretion of the fire chief and how the SJC dealt with it, it certainly is related, that's all.
I appreciate that, now I will read it. Okay, Peter, anything else you want to present this evening?
So, just a quick question, I briefly summarized kind of the status of where we're at with Conservation Commission. I don't know if you have anything to embellish in terms of new information from our team. You don't, okay, that's fine.
Mr. Chairman, I did speak to Joe Lynch, the DPW, and as promised, he had spoken to consultants from the applicant about the stormwater issues, and I understand from Mr. Lynch that there's supposed to be some additional material coming in from the consultants because there were some sort of gaps in the information that had been supplied, and so that there's further investigation being done on the stormwater.
That's correct. We're coordinating with the town and with an underground subsurface investigation of the pipe cleaners, and they're going to camera the flood drain in Elliott Street and Central Ave to find out condition, the size, where they go, so we can get to the bottom of some of the roof drainage issues and capacity.
Thanks.
Okay, good, thanks.
How long do you think it will take to have that?
It's underway. We're waiting to hear whether we're going to get them out there, maybe a week or 2 weeks.
Okay.
So we don't have more information. I would only give a very brief response or commentary to the list of the 4 main items again, which, as we all said, we agree, those are clearly the issues that presumably you would address in both the further hearings and your deliberations. On the traffic and parking, I will just say very generally, we understand the concerns that people have expressed, except we do believe that both the town peer review consultant, Conley Associates, as well as our traffic engineer, have basically satisfied our burden, certainly, that we're really not exacerbating a situation and that we're not creating any safety problems. And I know the parking is often perception, and I just have to defer to the experts that in fact there won't be any increase or detrimental impact, increase in a problem or detrimental impact from our project on the merchants and the local parking situation. On the fire safety, I won't say any more. Again, we'll address that again, have Kevin Hastings back at the next hearing. On the Conservation Commission, the memo that I submitted, the only thing that I would say briefly is that the reason that I do think for the 40B application, it is still meritorious for you to grant the waiver is it's supposed to be the one-stop shopping. You know, we certainly are optimistic and hopeful that we work all things out with the Conservation Commission, and the state standards which are applicable will cover that. If we disagree on interpretation of standards and the state code, then there's a DEP appeal. If there should be some disagreement or something that we would believe is not done properly, I don't believe that we should be burdened with having to file an application to the local Conservation Commission under the local regulation and have to deal with potentially a separate appeal, be it by us or frankly by neighbors, if somebody had standing. So again, I absolutely understand that your threshold issue is a comfort level. If you're not sure about the question of is it more stringent or less stringent, and are you therefore, by granting a waiver, subjecting the project to less scrutiny or perhaps to lower standards, then I could understand that maybe we have to go further to satisfy you. But since the memo shows, and we're happy to discuss it further if you want, but since the memo shows that there aren't any more stringent standards, we believe that it's well within the spirit and that we're entitled to, under 40B, to have that waiver. It's as simple as that. To have to create another level of application and potential appeals, you know, I don't think that that's what 40B was intended to do.
Do you have a sense, Peter, of whether the Conservation Commission agrees with your view on the stringency of the local bylaw?
I can't say that I discussed it directly. That didn't come up at that hearing that we went to, and I think this memo was after that hearing. But the short answer is, I don't know that they could assert that there are more stringent performance standards because of the language that I cited. You know, in the material respects, the wetlands bylaw locally and the regulations say we adopt by reference the state DEP standards, performance standards. And there were a few differences, as I pointed out. I wanted to be very thorough, quite candidly. I thought I could just kind of summarize, and I said, no, in fairness both to you all and as well as to me, so that I wouldn't miss something. As you saw, I went through each and every section, and there are some minor differences in definitions, which don't amount to anything in terms of any material differences there. And then there were those 3 or 4 things at the end of, I believe, the regulations. I believe it was section 6, where, as we pointed out, and these could be conditions. So when I say waive, yes, waive, but my intent is that we agreed that the erosion control provisions, to the extent they might be more stringent, we agreed with complying with those. To the same with the oil separator, makes a specific reference to certain standards, and we agree. We will be doing that. That's what's already proposed. There was a third one that I believe is immaterial in that it has perhaps some slightly different ways to flag wetlands, but that's not an issue here. I mean, we all know where the boundary of the river is. That's the only wetland in question. As you all probably know, if you have bordering vegetated wetlands and you have to have experts look at the species and the type of soil and all those kinds of things, there could be more of a question about flagging the wetlands. So we just don't think that that's material. And then the fourth one, the Conservation Commission could well do it with a state order of conditions, or if you felt there was some pressing need, you know, you could have it as a condition in the comprehensive permit. And that's the section of their regs, the wetlands regulations in Milton, that say they could establish a condition requiring some surety for performance, some surety or some type of restrictive covenant. I don't think a restrictive covenant comes into play here because typically, especially with conservation commissions, that's to preserve some open space and prevent development, things like that. But this is, you know, the previously developed property, so I don't think that that particular provision is relevant. And I don't think that surety itself is it doesn't seem to indicate surety in terms of what sometimes is done to assure completion of infrastructure. So again, I don't think that there's any harm that's being done to the town by those things because either they're essentially not applicable or we agree to, you know, to comply with them. So I would say, in essence, that's our show for tonight.
Any questions?
Not sure about that, but on the environmental reports, Mr. Cordero, would he be able to give some kind of a summary for us of what those reports that were produced? Do you think that would be
Sure.
Oh, actually, I meant, thank you for mentioning that. I meant to just clarify with what the chairman started off with, you referring to the prior site contamination reports?
Yes.
Yeah, thank you. I meant to ask about that myself.
We submitted as a request from the last hearing, the 21E report that was done on the property, as well as the Mass DEP RAO classifications from 1997 and 1998. We submitted them both to this board and to the Conservation Commission, and they were very much a point of discussion with the commission last Tuesday evening. And what we certified to them is the fact of the matter, as documented by the DEP summary sheet, is that the oil leak that was experienced and the subsequent cleanup to it is now a closed matter in their eyes, and that they've certified the site clean to the best of the abilities, with the cleanup without the removal of the building. And that's what we testified to last week. So as far as development opportunities that exist for this property, there are none. There are no limitations. There is nothing that would preclude us from moving forward with any of these actions. What the commission had asked us to do is to then reconfirm the soils underneath the building, reconfirm anything that's in the tanks or anything of that nature. And the applicant went on record that we are certainly willing to do that at the appropriate time. That is to say, when we can remove the building from the property and be granted access and so forth, we would go forth with evaluating the soil underneath and evaluating the wells in the former tank that's underneath the parking lot area. I don't know if that sufficiently addressed your question, or if you had a specific one you'd like me to attack for you.
Is the most recent report I think I remember seeing was, what, 2000? Or
Was 2000, that's
okay.
right.
And there hasn't been any activity on the site since then, and the wells haven't been monitored since
Correct.
that time?
Correct.
Okay.
And the reason for that, and again, the commission brought it up, is, why hasn't there been any activity on the site? At the closure of the DEP process, it was a closed case in their eyes. The source of the contamination had been removed, the soil had been remediated, and everything was classified clear to proceed, so no further monitoring was required. Now, because of the outstanding action on the property, when the transfer of ownership took place, a 21E had to be noted, it had to be conducted, and that's the report that we provided, and that summary denoted that the case had been closed, and again, no further action was required on the applicant's part to proceed.
And that's the report you're talking about that was in 2000, or is that more recent?
2000.
2000, yeah,
Yes, sir.
okay.
And so what is it that you would do after the building? If the building were removed, what would you do by way of further testing or evaluation? Well, our action really stands in that we need to remove the old tanks that are underneath the parking area. So those have to come out, and any material inside there has to be disposed of in accordance with the DEP regulations. We're not anticipating any soil remediation required in conjunction with that because of the nature of the tanks and because of the reports that we have in our files and that have been presented to both of these boards. And then in the area of the lower machine room, which exists inside the footprint of the building, where we had the contamination spill and all the soil remediation, the report notes that we weren't able to achieve full background levels, and that's because we couldn't excavate further because of the limitations of the existing building. So anything that's within there, and again, classified as being none, all of that soil actually has to come out as part of the project regardless, in order to make way for the underground parking structure that we're proposing. If any soil that is in there is contaminated in any way, shape, or form, it again would just be disposed of in accordance with DEP regulations. So we'd have to retain the services of an LSP, a licensed professional, to oversee that process and make sure everything is done according to the regs. So presumably we can make that a condition to any approval, that if we were to issue an approval. Okay. Anything else? No, sir. Frank, questions?
Nope.
Ted?
Nope.
let me just pose a question that you don't have to answer, but you might think about between now and the next hearing. And I ask these questions more to be a devil's advocate than I do necessarily to reflect any current way that I'm thinking. So don't read too much into what I say. I just like to test you. But to go back to the traffic issue and the signalization issue, I think reasonable people could differ about that issue. And from my perspective, I think I made the point at one of the hearings, maybe it was the last one, I sort of shared the point that you made, which was I don't think it's fair to, if it's determined that a traffic signal is appropriate at some point in the future, and it hasn't, I don't think it has been yet, I don't think it would be fair to burden you guys with that. I don't think it would be fair to make you be the applicants or to carry the flag on signalization. But what if we were to say to you, if, as and when the town decides to go forward with a traffic signal, what if we condition this approval on some economic contribution, not the whole thing, but some economic contribution to that signalization? Just something to consider. And I don't have a number in my mind as to what that would be, but it seems to me that that would be a Solomonic approach to this issue.
Well, not meaning to dub myself Solomon as well, but I was honestly going to say great minds think alike, because we have discussed it naturally. And, you know, we're all attorneys, you and I, land use attorneys, and appropriate mitigation can be perfectly fine. My thought actually was a little different, and it may be rhetorical. I don't have an exact amount either, so I'm not going to just throw out figures. We obviously think it should be, you know, reasonable and, you know, somewhat proportional and all of that, keeping in mind that it's, again, an existing condition. My thought was actually, since the first step is a study, which, as I understand it, can be fairly expensive, my thought was that the condition would be if the town wants to proceed with a study, and I have to put a time limit, but whether it's 2 years or 3 years or 5 years, that my client would provide some payment of X dollars towards the study, because I think that that's the first step. And again, I think that that might well help the town. They would have to come up with all the money on their own if you know, because as you heard and probably knew anyway, that you can't just do the traffic study. You're going to have to do all of these fairly sophisticated and I believe fairly costly studies. So again, my response is it's absolutely right on, I believe, in terms of appropriate conditions. And then the details, of course, will become important. So I appreciate you mentioning at this stage.
Second rhetorical question, and again, I don't mean to suggest that I have an answer to this or that or it reflects any particular way that I'm thinking. But leaving aside the code compliance with respect to fire safety, and I appreciate that, and I'm familiar with your firm, and I think people at my firm have used your firm on a number of occasions on fire issues. Is there some other way to address the issue on the side of the building on the MBTA? Some practical way that would address the fire chief's articulated concern?
I don't know. I don't know. I don't think we should give answers off the cuff.
No, I don't want you to, but
Yeah.
it's just things to think about for the next hearing, because it's the things that are on my mind.
Mhm.
And those are really the two principal ones. Any other thoughts that people have that?
No, I think we've been over questions about trying to address any parking concerns, haven't we? We've kind of talked about that.
I think we've addressed, I think we've,
Yeah.
I'm not sure there's much more to be said about parking. I mean, it's staggering if you go, I mean, I was there Sunday morning, and it's just staggering to see the parking that's associated with Steel and Rye. I mean, it's amazing. They do a brunch there now, and God bless them, they're doing very nicely, I guess. But it's unbelievable. You can't find a place to park over there. But presumably this project wouldn't really have an impact on that. Of course, I mean, the parking concern I think that we all have, but again, we don't have the expertise, and we have to rely on what people present to us. I'm still very skeptical about the notion that the number of spaces that's being provided is adequate. Now, I guess the way you answer that and you address it is you say, well, we tell the people that rent these units that they get one space and that's all they get, and that's it. And so tough luck. If they want to have 2 or 3 cars there, they just can't do it because they can't park on the street because there's no overnight parking. I presume that's what you would say is the complete answer to all of that. I'm not sure that that's necessarily a complete answer, but I understand it. I understand what you're saying. But to me, it's counterintuitive, frankly, to think that 57 apartments is only going to need, whatever it is, 77 spaces. I find that in this modern world where I come out of my own driveway tonight and I've got 5 cars in the driveway, I find it's really hard for me to believe that that's going to work. But so it's just something that's on my mind, and you can address that or not address that in any way you choose to at the next hearing, but it's a lingering issue for us. And I mean, one way to deal with it, and I know it's sort of verboten to even suggest this, would be to reduce the number of units that's being proposed. But I don't even want to get into that whole issue of whether it's uneconomic and all of that. It's too complicated for my mind. But it's something I think that is a lingering concern, probably for all of us. So enough said on that
Sure.
point. I just wanted to give you some inkling of what I'm thinking about as we go through this process.
Sure, and we'll certainly, think about that, again, not by way of reducing the size of the project, and I don't know that we have any ability to come up with more spaces, but in terms of honing in on the analysis, I can say, and it's not really anecdotal, but, I do know several things. I mean, the statistics that the ITE has, it's because of the proximity to the mass transit. And that's a crucial factor, because I've done developments that are more suburban, and we know that, something, 1.5 or closer to 2 per unit is more appropriate, and that's kind of where the logic is consistent with the reality. But those are in more suburban sites. I've done projects where they're right at the MBTA commuter lines, and this is not commuter rail, although it's close, but it's obviously the trolley line, so there's access very, very close. And the projects that I'm familiar with do have similar numbers, so again, it's not just a kind of book that's so general, even though it's based on voluminous data that the Transportation Engineers Institute has assembled, but, I know from experience with other clients. And, the other thing is, which goes to what you summarized as our response, which certainly is largely our response in terms of how we limit the parking, but we can make sure that we have appropriate, I'm sure you do this anyway, but appropriate provisions in the lease, and even, stickers or coupons or whatever you would call them, that would be on the cars, and that means the management staff can monitor if people are using spaces that they're not supposed to, and they're very strict standards as to, hey, you get towed if you do that. So things like that just add some teeth to the fact that, they're gonna control the spaces that are there, even guest parking, that perhaps it could be controlled more tightly. So, again, we
You may consider laying that out in some more detail for us, as to
Yeah, we can
exactly
come up
what
with
that
a
would be.
management program.
I can tell you that, having grown up in South Boston, and now going back there since my daughter lives there, parking is a huge problem in South Boston. I mean, it's an unbelievable problem, to the point where they banned all visitor parking there. So the notion that people are going to happily be in their little apartments with one car, I don't know, just doesn't resonate with me, but I'll see what kind of
But then
things you
again,
guys...
Boston itself and their new codes, because I've actually more for my law school class with case studies, but they actually are really restricting the number. They'll reject you if you have too many spaces. I forget what the standard is, but it's quite low to have, because they really want to say, let's get cars off the street and let's basically force people to use mass transit. So.
It's an interesting problem. Okay. Well, I appreciate the information you guys have presented this evening. Let's talk about a next hearing date. I think it should be in December. I think it should be sooner rather than later, if we could do that.
Yeah.
I'd prefer not to have it be really close to Christmas. So I'm going to look to the estimable scheduler here to tell us when we have availability. Okay. What's a realistic time frame for you to assemble whatever additional information?
Yeah, I don't know how much.
When is the next Concom hearing?
December 9.
I'd like it to be after the next
I agree.
Concom hearing, and I'd like to get some sense of what happens at that hearing. And indeed, it would be great if the chairman of the Concom might even show up at the next hearing if he were available. And I'll leave that to you to deal with.
But then the stormwater stuff, you said, what, that's a couple weeks?
Yeah, we need a couple of weeks to pull everything together because it's
Okay.
actively working within Central Ave and Elliott Street and coordinating police details and access with the DPW director and the town engineer.
3 weeks from today is December 16th. Would that work?
Makes sense to me. It
I'm sorry.
would be a
What does that mean?
good night for me.
It looks like it's okay. Does that work for you?
Yeah, that should be okay.
Does that work? Okay. So December 16th at 7:30? Does that work for you guys? Yep. Is that all right, Peter?
Yes, that is, thank you.
All right, before I would be remiss if I didn't present the opportunity to those who are present tonight, if they wanted to make any comment or ask any questions, to do so. If there's anyone who chooses to do so, you have to come forward, sit at the table so that your voice can be heard and recorded. Is there anybody that wants to speak this evening? Yes, sir. Just anyone else that's going to come forward tonight, or is this the only person? Okay, I guess you have the sole spot tonight.
Good evening. My name is Craig McNaught. I'm a resident of 14 Herrick Drive in Milton. I have a couple questions in regards to this project. I'd like to know if the MBTA has signed off on the project, the site work for the project.
I don't believe that that's a requirement yet. We know we have to work with them, so that's certainly something to be done. If the engineers have any more specific.
So the answer
The
is
answer is not
they-
yet,
that
but.
they would have to do,
Yeah,
sign
there's
off
some-
on-
There's some coordination
Oh,
near
yeah.
near the
You have to-
tracks.
Yeah, you have to get a permit.
Yeah,
Right.
a permit to do what?
To get access to access the site from the tracks.
Okay.
yeah.
You might
I mean, I
probably-
believe that's been discussed with the, building contractors I've spoken with. It's nothing that's that unusual, but yes, it's something that would have to be done.
Now, the
Okay.
parking garage is going to be underneath the building,
Yes.
okay? Do you anticipate you're going to be into ledge doing that excavation?
Well, I can defer to the engineers, but I don't believe we're anticipating it, no.
Well, the monitoring wells encountered ledge.
They have the borings and they can respond?
Sure, I can respond to it. And you're absolutely correct. In the monitoring wells, they encountered some ledge 4 feet below the low elevation of the lower machine room. So we'll be skirting probably very close to a ledge condition. And if anything, it would be removing some fractured shale presumably. We haven't done detailed testing inside the footprint, so we can't confirm the extent. We're basing it off of the same reports that you reviewed that indicated the presence of ledge. So we don't know the quantities yet.
My concern is that if you have to take the ledge out and you're going right up to the property line adjacent to the MBTA track, and you're going to be below the MBTA track, okay, will all this be done as part of the diversion cost?
I just wanted to let you finish, I apologize. Just 2 clarifications in that, we're not going directly up to the property line, as Chris alluded to earlier. On the backside, we do have a 5-foot separation. But then in conjunction with that, the parking structure is not under the entire footprint of the building. There is a depth, I believe, between the back face of the wall and the parking structure underneath. Is that correct, sir?
Down to 25, right, we're down at elevation 25 for the garage? Right. Yeah, and the tracks, we're not below that, the tracks are at 23, 24, 25, 25, so the garage elevation is gonna be at grade of the track.
The floor of the
The floor of
garage?
the garage is gonna be at grade of the track.
Okay.
Right.
I wasn't able to ascertain that from the material that I have.
Anything else?
That's a pretty good start,
Okay, I agree.
okay? My concern is that if it takes a long time to excavate the ledge, is that gonna be part of the diversion cost that has to be assumed by someone? Or is that gonna be part of is the diversion cost for the ledge, if they encounter ledge, is that gonna be on the building contractors? Or is that gonna be on other people's?
Okay. You understand the question?
I understand the question. I don't have a definite answer.
Okay.
I have a supposition, but I won't state anything.
Mr. Chairman, once the demolition is complete and we have a site plan to work on, any ledge encountered to install our building would be our cost, any other diversion.
Yeah, but my point is, will the MBTA, have you talked to the MBTA, if you encounter ledge, will that have to be, incur a there's gonna be a diversion cost to take down the building? Is that a second diversion cost to take out, to take out the ledge?
If it were necessary, it would be a second cost, if a diversion was necessary.
Okay. Do you anticipate that you're gonna crush the ledge on the site the way they're gonna, you anticipate to crush the concrete from when you take down the building?
It depends on how, if there is ledge, it would depend on how the ledge breaks up.
But right now, you anticipate bringing in portable crushers to crush the ledge and the concrete?
The concrete, the existing structure, we haven't contemplated what we're gonna do with whatever ledge we break out of there, if any. We haven't contemplated that yet.
I don't know if you gentlemen are familiar with portable crushers.
Can't lay claim to that.
Okay. They're about 40 feet long, the primary and the secondary. Okay? You come in on a trailer, hitch them up, and it has a tendency to be a little bit noisy and dusty.
Okay.
There's been a series of portable crushers up in 128 at the 95 interchange. I don't know if you go by that area at all.
What's the alternative to that?
Pardon me?
What's the alternative to portable crushers? Is there an alternative?
Is there? Yeah. Don't crush it. Just remove it. It's more economical for the builder if he can crush it at the site, and then he tends to use it as part of the building process. That's fine, but I understand there's one residential house that's 12 feet away from this whole project.
I mean, legitimate questions that perhaps we can address at the next hearing. Okay,
Thank you.
I appreciate it.
Okay.
You've touched on things that perhaps we wouldn't have thought about, so.
Pardon me?
I said you've touched on things that we probably wouldn't have thought about. I
Yeah.
appreciate that. Anyone else that wants to be heard this evening? Great, well, we've agreed that we're going to postpone and continue the hearing until December 16th. And at that point, we'll just sort of have to assess where we are in terms of whether any additional hearings are necessary or whatever. I mean, just by way of forecast, Peter, what I have in mind is that when we close the public hearing, I would have in mind that we would not immediately deliberate that night, that maybe we would come back in a couple of weeks and do our deliberation in a public meeting, because there's a huge amount of material. And I sort of foresee that at some point, as painful as it is, I'll probably have to come to the town hall and make sure that I've got everything and I have a chance to read everything. And then I think that would make for a more intelligent deliberation. So that's sort of where I'm headed with
Sure,
this.
and actually, since you mentioned that, which is logical, question, what's your protocol, if any, on the timing of doing a draft decision, and then whether if the hearing is closed, I know some, difference of opinion between town attorneys as to, under the open meeting law, whether the applicant can participate even after the hearing's closed in just discussing the conditions in the decision. I've had boards do it both ways, and also the initial question is, again, when do you think a drafting is appropriate?
I'm not, well, I'll have to think about that. We don't have a protocol because we've never done a 40B before,
Yeah.
so we just kind of.
Then I'll tell you how we do it.
Okay, we're moving along one step at a time.
Yep.
I'm always reluctant to do anything that's inconsistent with the open meeting law, even slightly. I mean, my inclination would be, once we do the public hearing, to deliberate, then once we've articulated what our decision is and publicly sort of address what we think the conditions should be, then one of the three of us would probably draft the decision, and we'd probably do it that way. I mean, that would be my preference to do it, but I can't speak for everybody else on this.
Sure.
So we'll get to that point later.
Yep, absolutely.
We're
Good.
probably going to draw lots as to who actually gets to draft the decision.
Yeah.
Well,
So-
Mr. Chairman, in some cases, as Peter knows, in some cases, the town council drafts it, does a first initial to make sure that there's sort of the format of it all set. The conditions, Peter and I, in prior iterations, have met, with the board to go over those conditions in an open meeting. Obviously, there's no new material provided, but there is certainly the discussion of what those conditions are going to be. So that could be something that I could help with.
That's
if
great. We'll
necessary.
cross that bridge when we come to it, but you've given us things to think about as to how we'll proceed on those issues. Yeah, I have lots of 40B decisions by
Yeah, I know,
various
I'm sure
boards
you do.
around the state, so I
More
sort
than
of,
me.
I sort of see what they do in terms of conditions and what works and what doesn't. But I'm happy, we'll step this out as the
Sure.
process goes on.
Absolutely, yeah.
Okay. Great. Well, we'll close the public hearing then for this evening. Thank you for everyone who's attended and given us information tonight, and look forward to seeing you on the 16th. Happy Thanksgiving to all of you.
Thanksgiving.